request the panelists to please take their seats. Students, please take your seats. All those entering now, please take your seats quickly. All right, good morning and welcome to the second day of the third International Symposium on Law and Peace. Yesterday, we had the inaugural ceremony followed by two insightful sessions on peace building and sustainable development, followed by global trade, governance, and law. Today, we are going to maintain the tempo and keep up the spirit with two enthralling sessions followed by the valedictory session. I, Rishi Kapadia, a fourth-year student of BBA LLB Honours, along with my co-host, Sania Nagaria from first-year BBA LLB, are going to take you through our session for today.
In keeping with the 4 decades old tradition and legacy of MIT World Peace University, we shall first begin with the World Peace Prayer, an anthem of unity, spirituality, and learning, which knows no religion, caste, or creed. Please stand up and join your hands for the prayer. I request our technical team to relay the World Peace Prayer.
जय जय स्वसंवेद्या आत्मरूपा देवातूति गणेश कलार्थमति गणेन रुद्रिकासु अवधारि बोधि गुरुर्ब्रह्मा गुरुर्विष्णु महेश्वरः साक्षात् परब्रह्म तस्मै श्री गुरवे पूर्णमिदं पूर्णात् पूर्णमुदच्यते पूर्णमादाय पूर्णमेवावशिष्यते ॐ शान्ति शान्ति शान्तिः.
Thank you. Please take your seats. Our theme for this third session of the third International Symposium on Law and Peace is Artificial Intelligence and Law, the Way Forward. We currently stand at the dawn of a new era in the human race. Artificial intelligence, an incredible force which has taken on the world by storm, especially in the last few years. Tools like OpenAI have revolutionized every domain in the modern world, from academics to business management to strategic planning, scientific innovations, the arts, and of course, law. Hence, it is only just to discuss the advent of AI and its impact on the law. And for this discussion, we have an exceptional and illustrious panel of legal academicians and practicing advocates here with us today. Now, I call upon Dr. Santosh Kumar, Dean and Professor, School of Liberal Arts, Department of Public Policy and Governance, MIT World Peace University, to deliver the welcome address. Let's welcome Sir with a round of applause.
Good morning. So it's my pleasant duty to extend a very warm uh, welcome to all the illustrious guests on the dais, my colleagues of the dais, and my dear students. I, on behalf of the founder president, Professor Dr. Vishwanath Karad, our very dynamic executive president, Shri Rahulji Karad, the entire management and faculty, welcome you all to this in this pleasant morning and for this very interesting and thought-stimulating session on AI and law. So, Dr. Anant Padmanabhan, Advocate Neha Rai, Advocate Yogesh Nayyar, Advocate Mukul Shastri, and everybody, thank you for finding time to come to MITWPU and addressing this particular session. Friends, I'm a public policy person, so from that perspective, I do visit many NLUs. I'm not a subject expert, I'm not from the background of law, but I understand the policy and the law relationship, and I'm trying to understand it more. In this particular relationship, I think introduction of technology and artificial intelligence and many other assisted technologies are the buzzword these days. I feel it has been popular among those people who practice AI and are looking at the subjects because of its ability to solve many real world problems in advance. AI has been involved in many fields such as medical, banking, and you name the sector and it will be there. Particularly the social science and the sectors which are associated with social existence. Many law firms are still using outdated technologies, or they were. Now they are not more, no more any time, and software to their work. So they are not tended to use modern technologies such as AI to make their progress easier and effective. AI allows lawyers to automate their regular work. This is what I have understood after discussing with some of my friends. Yesterday, I was just thinking, what should I speak when I'm going to deliver the welcome address to my guests? And one of my colleagues from School of Law, she helped me with certain points. She said that, sir, this is what we would want to hear. So she shared with me 4 points, and I completely endorse those 4 points when we talk about AI and law. So explainability and transparency in the legal affairs, which explores the legal challenges associated with the law of explainability in certain AI systems, and the growing demands for transparency in decision-making process. I think this is the core of AI and law. Second was human rights implications, regulatory gaps, enforcement mechanisms, so on and so forth. I think this session is basically going to throw light in inclusion of technology, law, and its implications for the society. And I'm sure the illustrated panel here seated with us is going to throw lots and lots of thought-provoking ideas onto us as to how to use the AI, which can be helpful to make the law field more efficient and effective. With these words, I extend my heartiest welcome to all of you once again, and thank you. And I'm looking forward to a very thought-stimulating session ahead. Thank you very much.
Thank you, sir. In order to set the tone for this session, we have prepared an introductory video on our theme of artificial intelligence and law, the way forward. I request our technical team to play the video.
This session is based on artificial intelligence and law. The development of AI technology provides an opportunity for lawyers to improve their efficiency, reduce costs, and focus on more strategic work. AI can handle mechanical and routine tasks like document and contract review, legal research, and data analysis. This can ultimately lead to increased productivity and profitability for law firms. However, AI is not yet capable of handling more complex tasks, such as deal structuring, negotiation, advocacy, and representation in court. This session aims to foster a nuanced understanding of how AI is reshaping traditional legal practices, from automating routine tasks to influencing decision making processes. It dwells into the ethical considerations surrounding AI, addressing concerns of bias and transparency, and emphasizes the need for an adaptive regulatory framework.
Thank you. And in light of this introduction to our theme, it is time to felicitate our speakers on today's theme. In the true MIT World Peace University tradition, I request our Dean of School of Law, Dr. Sunil George, Dean of School of Liberal Arts, Dr. Santosh Kumar, Program Director of School of Education, Professor Parimal Sudhakar, and Program Director of School of Law, Dr. Abhijit Dhere, to felicitate our guests. Please put your hands together for our guests. Our first guest is Dr. Anand Padmanabhan, Dean of Vinayaka Missions Law School. Our next guest is Advocate Neha Rai, practicing advocate at the Supreme Court of India. Round of applause, please. Let's keep the applause going. Advocate Yogesh Nair, founder of YVN and Associates. Round of applause. Dr. Mukul Shastri, General Counsel, Cube Highways. Round of applause. Let's keep the applause going.
Before we move forward and start this much awaited session, I would request our media team to kindly capture this moment with a group photograph of all the dignitaries on dais. I request all the panelists to stand at the front of the stage for the group photo along with the ISLP brochure. Thank you.
Let's have a round of applause for our amazing panel.
Now, I request Session Coordinator, Assistant Professor Shubhi Trivedi ma'am to address the gathering.
Thank you, Sanya. Ladies and gentlemen, honored guests, esteemed colleagues, and my dear students, a very hearty and a warm welcome to you all on the second day of the third International Symposium on Law and Peace. As the theme for this session is AI and law, the way forward, it is important to delve not only into the advantages of AI, but also the repercussions it carries with it. In the recent years, we have witnessed unprecedented surge in technological advancements, and at the forefront of this revolution stands artificial intelligence. AI, with its ability to learn, reason, and process vast amounts of data, has begun to permeate every aspect of our lives, including the field of law. As with any major advancement in technology, it brings with it a spectrum of opportunities as well as challenges. On one hand, several applications have been developed or are under development with the potential to improve the quality of life significantly. On the other, we see complex issues arising from them. For instance, as per a study, AI is expected to double the annual growth of 12 developed countries by 2035. On the other hand, there is a possibility of job loss. As per the available reports, the loss of jobs during the next 10 to 20 years is estimated to be 47% in the United States, 35% in the United Kingdom, 49% in Japan, 40% in Australia, and 54% in the European Union. However, with great power comes great responsibility. The infusion of AI into various systems brings forth a host of challenges and ethical considerations that demand our careful attention. Therefore, the path forward requires a thoughtful and deliberate approach to ensure that AI aligns with the values and principles that form the bedrock of our legal system. In order to assess the current level of adoption of AI technology, there is a need to look into the applications that have been developed across the world. Some of the areas of AI application include healthcare sector, education, cybersecurity, law, banking, e-commerce, virtual assistants, among many others. With such wide applications of AI, the challenges are also complex. And therefore, the need of the hour is to formulate and implement laws and policies to tackle such challenges. On those lines, one of the foremost concerns is the establishment of transparency and accountability. Privacy concerns also loom in the age of AI. Furthermore, the legal community is also seen grappling with the issues of liabilities. On this point, it becomes imperative to note that in April 2023, the Ministry of Economics, IT and Telecom reiterated that Indian government would not be enacting legislation to regulate the growth of AI in this country. This comes out in sharp contrast with other countries around the globe, which 31 countries have since 2016 passed at least one AI-related bill. With this, it is also important to analyze and understand whether AI can be used as a tool for establishing peace and governance, or whether it is a tool that can disturb peace and governance. On that note, ladies and gentlemen, I leave the session open for further deliberations by our esteemed guests for the day and hear their views on today's theme of AI and law, the way forward. Thank you.
Thank you, ma'am, for laying the foundation upon which the addresses of today shall build. And on that note, I am elated to introduce our first speaker for today, Dr. Anand Padmanabhan, Dean of Vinayaka Missions Law School, VMLS. Dr. Padmanabhan is an expert in intellectual property rights and technology policy. He holds several stupendous academic qualifications, including a BA LLB from NLSIU Bangalore, an LLM and doctorate from Pennsylvania University, and a business degree from Stanford University. He has formerly held several leadership positions, including founding Dean of Sai University's Law School, and team leader for the Technology and Policy Research Vertical at Carnegie India, where he curated the inaugural edition of Carnegie's Global Technology Summit, an annual flagship conference. He takes pride in having created India's first residential fellowship for lawyers, the Daksha Fellowship, with its primary focus on technology law and policy. He has authored and contributed to and edited several highly acclaimed and recognized academic pieces, including Intellectual Property Rights, Infringement and Remedies, and India as a Pioneer of Innovation and Regulation, Design Capacity Performance, which focused on big data. He engages in broader public conversations on the impact of technology through his opinion pieces in Hindustan Times, The Print, Live Mint, Indian Express, and other significant mainstream print and digital media. It is an honor to have a man of your caliber with us today, sir. Please put your hands together for Dr. Anand Padmanabhan.
Thanks, Rishi, for that wonderful introduction. And I think, starting the session is always an onerous task. But let me begin by paying my respects to Dr. Santosh Kumar, Professor Shubhi Trivedi, Advocate Neha Rai, Advocate Yogesh Nair, Advocate Mukul Shastri, and of course the Associate Dean Professor Parimal Sudhakar. And thanks to the organizers, of course the Dean, Dr. Sunil George, and all of you here for having me here, providing with this opportunity to speak and share a few thoughts. This is an area where I think I can't claim to have too much expertise when it comes to the developments of the law in the very recent past, but this is an area which has been very close to my heart from the time I transitioned to a career in tech policy at Carnegie India's regional office in New Delhi. And it was an interesting time in 2016 when we did the first edition of the Global Technology Summit that Rishi just mentioned. It was a period of, I would say, techno-optimism. And for those of you here, I think you would probably look up to poster boys like Zuckerberg and some others when it comes to that term. But very interestingly, when we did the second edition of the Technology Summit in Bangalore in 2017, we were taken over by a sense of tech pessimism. And that was on account of one very particular event, which was Cambridge Analytica. And then people started waking up to what could go wrong when artificial intelligence and black box algorithms and data profiling, all of that combined together to influence voter behavior. And then, of course, from there on, we've been having far more mature conversations, and I think that's a good sign, about what we need to do in order to keep artificial intelligence under check. But let me also provide a reminder here that these are not in some ways new debates. In 1978, famously James Watson, part of the Watson-Crick combo, who came up with the DNA helical structure, thundered loudly, "We are accused of playing God, but if we don't, who will?" So we go back to that time when there was advent of innovation when it came to DNA profiling, and there were scientists who felt that we need to keep pushing the envelope. And today we see something very similar. Some of you, if you heard this without the name of the speaker, would probably attribute this to Elon Musk or someone else. So similar debates are in fact repeating in very many interesting ways. I think all of you here have a sense of what artificial intelligence is, what neural networks are. So I'm not going to belabor that point. I think we have enough understanding of how pattern recognition works today. We are seeing deep fakes around us. I mean, celebrities having their images reproduced, what we call generative adversarial networks that work against each other to achieve a certain degree of perfection. So there is all of this happening, and I'm sure we all are aware of it. So today, what I will do is, and I also am aware that my fellow panelists are experts in very specific domains, like how artificial intelligence is playing out in the world of litigation, in the world of business, in the world of criminal and justice delivery system, for instance. So I am going to stay clear of these very specific sectors and give the opportunity to my fellow panelists to really go deeper into that. What I will do instead is to just focus on 4 or 5 general principles which I think can be very useful for us to think of as a society when trying to develop a blueprint for AI regulation. And the particular reason for that, of course, being that India has currently chosen not to have a special legislation. To me, that is not always a negative, because sometimes you can have legislations and those legislations may not do much. So we also need to be careful that we don't get into the legislation washing, situation that sometimes we see in certain cases, like environment is a classic example of that. So therefore, I would say that instead of looking at whether we do have one or not, maybe we could go to one level of abstraction beyond and start thinking of what any kind of blueprint for AI rights and responsibilities could look like. I would venture to maybe go a little deeper into some of these points as well in the course of the remaining 5 minutes that I have. The first aspect which I think any focus around AI regulation needs to build on is the whole idea of, are we doing this in a safe manner? So before we get into questions around data privacy, algorithmic discrimination, etc., is the product safe purely from the point of view of outcomes? And it can be unsafe from various different vantage points. For instance, we know this whole study done on a product created to diagnose sepsis in patients in hospitals, which suffered from both over and under inclusion, in the sense that there were people without sepsis who were identified to have it, and there were people with sepsis who were missed out. So there is that one question of over and under inclusion. Then there is the separate question of unintended consequences. We have seen studies done on various products, including one meant to protect children by giving trackers that can locate where they are, and which were in turn used by people, misused rather, in order to find out more personal details about the very same people or very same children. Right? So we have cases of unintended consequences, which again we need to, as a society, think far more deeply about. So the question then is, considering that this is important, how does one respond to this? There are 2 levels or layers at which one can respond. The first layer of response, and increasingly this is going to become more prominent, is the tech layer of response. How does the technology itself build in an idea of safety into the very design of the product? And why this becomes important is because as artificial intelligence proliferates every sector today, imaginable, mobility, healthcare, food delivery, so on and so forth, governance, we may reach, or we surely will reach, a point where the legal system and policy responses may be under capacity. So there will be an issue of regulatory capacity and bottlenecks. So we cannot build our response primarily on law and regulation, in my humble view. We have to start with thinking about how does the technology alert in a layered fashion to various kinds of safety concerns that may exist. Similarly, how do developers report on how the technology is working out? So one mechanism that we are now seeing, which is at the intersection of technology and regulation, is what we call regulatory sandboxes. So you can release a code which is built on neural networks, see how that is working on a set of data, see whether there are biases and other kinds of issues with the way that that particular solution is playing out, and you constantly report. So there is a certain element of transparency therefore built into the way that the product is made applicable to everyone. Similarly, there are consultative processes that we can use. Sometimes, when we are now speaking about new ways of solving problems, including, for instance, in the financial sector, we see consultative processes being included so that individuals can, journalists can, and other citizen stakeholders can respond to how the code is going to play out. So these are two ways in which you can develop solutions within the code itself, to try and resolve these challenges of black box algorithms, as we popularly call them. But of course, we all know that this is not everything. There has to be some kind of a deeper legal response as well. And the way that now we are seeing that is through separate legislation on various different aspects. So we have data protection laws, we have algorithmic discrimination laws, we have other laws to deal with various other aspects as well. And those are, I think, matters where our other panelists for today will be addressing these in greater detail with respect to specific sectors. So I would only close out by saying that merely because we don't have a law, that does not mean we are on the wrong track. And merely because some countries have laws, that does not mean they are on the right track. The best way to respond to the challenges of artificial intelligence is really to have more consultative processes and to develop a blueprint built on whether the product is safe in the first place, whether the outcomes are met or not, and then to sort of start developing from that bottoms up sort of approach. Thank you for your patient listening. Happy to take more questions later. Thanks.
Thank you for your insights, sir. They added a great value to our program, and we appreciate your presence here today. Our next speaker is an alum of MIT. She is Advocate Neha Rai. She possesses a sharp business acumen with prominent management and leadership skill. She is registered with the Bar Council of Delhi and holds a bachelor's degree in law from Delhi University. Advocate Neha Rai works as an associate at Mridul Chambers along with her independent practice and appears regularly before many judicial spectrums. She gained an extensive research and drafting experience with a wide range of civil and criminal law matters during the clerkship under Justice Vipin Sanghi at Delhi High Court. She also gained immense exposure. We are honored to have you here today, ma'am. Please put your hands together to welcome Advocate Neha Rai.
Thank you, Sanya, for those kind words. And so thrilled to be back at MIT campus. It's always, it feels more like visiting home for Diwali, exactly the same feeling. By coming back to the campus and being in, particularly in this hall, we have attended so many seminars sitting over there. So, really great. And I would like to thank you all and MIT World Peace University School of Law and for making me part of this event and making me share this dice with these dignitaries. Thank you so much. So I am here. One more thing. I actually thought that session would be 20 minutes. So, and that it's more like 10 minutes, 10 to 12 minutes. So apologies for that in advance. Anyway, so I would be just sharing my experience in respect with artificial intelligence in last 10 years, whatever experience I had in the litigation, whatever the artificial intelligence plays a role in litigation and judiciary. So I am here just to share my experience. Okay, I want to ask how many Tony Stark's fan we have here in the hall? We have. Okay, so we must be aware with Jarvis. We are, right? So Jarvis is just a rather very intelligent system, which was later replaced by Friday, right? Which is female replacement intelligent digital assistant youth. Many of my friends didn't know this. And as a Marvel fan, I take pride that I made aware this fact to them. So anyway, my point of referring Marvel character here is just that no matter how advanced an AI could be, it still remains the creation of the mankind. It is just a creation. It is there to help. It is there to assist us. It is there to make our job easier. But it is not going to replace us. Um, as per Advocate Act 1961, only sin. They have the statutory right to represent before any court or tribunal, not any system. At least not, and I strictly and I strongly believe that in future too, I'm not seeing anywhere that system would be replacing the lawyers. So we are the Iron Man, we are not the Jarvis. So we would be saving everyone from the Thanos, I guess. So this is it. And recently, Chief Justice D.Y. Chandrachud, along with Justice Hema Kohli, they recognized AI as an assistant, as a surplus to the litigation, and not as a replacement. So, in the words of Hema Kohli, there is like, sorry. So AI plays a very important role in respect with legal research. In my days, if I remember, there were times we used to put the keywords in those boxes, and then we used to run to our seniors for the what would be the exact proposition, what would be the exact outcome of that result, and we used to spend tremendous hours, so many hours over one proposition. But now with the upgradation of the AI, with everything, the things has been made so much smoother. With the AI, okay, there is one case I would like to discuss. So in Tamil Nadu, there was one lawyer. So what he did that he took help from the Chat GPT in preparing his arguments. He just entered the required proposition and asked for the written submission for the final arguments. The arguments were there, submissions came, and he filed in the court. What happened later? That at the time of the final arguments, all the citations given in that particular argument were just fictitious. Not a real citation was there. So we cannot solely depend on AI. That has to be cross-checked. If we go for even for the research, we do see that particular judgment has been overruled or not. That particular judgment contains any that fact similar with the case we are asking for the relief. So we need to cross-check. That particular information has to be cross-checked. We cannot solely depend on the artificial intelligence. And if we talk about the opportunities and the positive outcomes of the AI, so in 2019, Supreme Court, with its SUAS, Supreme Court Vidhik Anuvad software, it came with it is a machine-assisted translation tool trained by artificial intelligence. This is specially designed for judicial domain and at present has the capacity and capability of translating English judicial document, orders or judgments into 9 vernacular languages, scripts and vice versa. This was the first step towards the introduction to artificial intelligence in judicial domain. And then we have virtual courts. We all know that at the time of the COVID pandemic, it was need of an hour. And then gradually, in Delhi High Court and its subordinate court, the hearings are hybrid. We can opt at the discretion of the judges. We can go for the hybrid until unless the stage is for any cross-examination or advocate has to present in the court physically. We can, at the discretion of the court, we can be there, we can be present at the virtually, and we can do the hearings. But that comes with the challenges. What challenges we face is that the lawyers, they are not very technologically, they are very friendly. They don't know what WebEx and how to, for example, if NCLAT Chandigarh, what they do, that if you are going to enter for a hearing through virtual mode, you have to specify your item number along with your case name and for the complainant or for the petitioner, and then only you will be able to join the window. But many of the lawyers who are not very well technology, they cannot appear. And what happened? Either it get delays, it get adjourned, or the case get dismissed for the non-prosecution. So these are the challenges also we are facing in respect with the artificial intelligence. But it is with the help of bar associations, other offices, every other day, every now and then, workshops are being conducted, and lawyers are being getting aware and well equipped with this technology. Then I would discuss one case where Delhi High Court, that is a very recent case. It's Anil Kapoor versus Simply Life and others. It's an IPR matter. So in this matter, what happened that the Honorable Delhi High Court yeah, sorry. So Honorable Delhi High Court, they granted a permanent injunction, ex parte injunction against the defendant, as they were using an artificial intelligence in for the morphing of the pictures, voices of the actor, and they were using in a commercial way, they were making money for it. So there, Delhi High Court particularly observed that the technological tools that are now freely available make it possible for any illegal and other unauthorized user to use, produce, or imitate any celebrity's persona by using any tools, including artificial intelligence. So these are the challenges we are facing on everyday basis. But we are also going ahead slowly and gradually. And with this, I would conclude my part with a saying of Swami Vivekanand, that Uttishtat Jagrat Prape Varatni Modhat, which means rise, awake, approach the great and learn, stop not till the goal is reached. Thank you so much. Thank you so much for your time.
Thank you for your valuable insight, ma'am. Our next speaker has a long-standing relationship with MITWPU School of Law, having graced several of our events. Advocate Yogesh V. Nair, founder of the pan-India law firm YVN and Associates, having offices in New Delhi, Mumbai, Nagpur, and Nainital, with a client base spanning the globe. With nearly 30 years of experience, Advocate Nair is a member of the International Council of Jurists, London, and holds the positions of an ombudsman and arbitrator with the Federation of Integrated Conflict Management and the International Commercial Disputes Tribunal. He is a member of the Advisory Committee of the National Museum of Forensic Science and holds a prestigious Lex Falcon Award 2021, recognizing him as one of the top 50. Advocate Nair practices predominantly in corporate laws and trademark regulations before the Supreme Court of India, as well as several high courts and civil courts across India. In addition to corporate and trademark practice, YVN and Associates practices in securities laws, arbitration and mediation, along with civil and criminal litigation. In addition thereto, Mr. Nair is a strong advocate for animal welfare, human rights, children's welfare, environmental protection, and multiple others. We are grateful for your presence here today, sir. Please join me in welcoming Advocate Yogesh V. Nair.
Don't know how to use it basically. So it's absolutely fine in case if you are in a position to help me out for that. So, see, the thing is, I'm really very thankful to you all for inviting me. The esteemed college which I have been associated with, the Honorable Vice Chancellor, Namaskar, the Honorable Dean, everyone, and to the welcome to the dignitaries and everyone. My dear students, I won't call you students in fact because you are lawyers in the framing. So you are equivalent to us. I have always learned in my career of 30 years span, we have not only been hearing that there are people who are juniors, but we have never been treated as juniors. Neither I treat my subordinates who are there in my office as my juniors. Because I sit in my office as a caretaker. My office belongs to Ma Vaishnav Rani, who I serve and I worship. And as per the introduction what my brother has given, today being here, for the purpose of delivering a lecture or sharing rather, I would say, because I don't believe in lecturing. I only believe in sharing. First part of law, as to what it is. When we say law, many of those who are here sitting right now, I may take few more minutes, more than 10, वो मंदिर की घंटी मत बजा दीजिएगा. Let it be a very different kind of a session, I would say. So, when we say law, what actually is law? Now, you all are students right from first year. I won't say that the first year students, no, it's absolutely fine. Thank you so much. The first year students of law, they might not be aware what actually law is. But then those who have reached their pinnacle in the sense their final year, getting or about to step into the profession after a few months or so, they need to understand, first of all, what is the definition of law. Now, what law is said is, recently there was a book release ceremony, and Honorable Justice Bhuyan, who is the presiding judge at Supreme Court of India, he was also there, and he has released that book that is on PMLA. So there I was supposed to speak, and that is what I said. It's very important for every one of us when we are there in the fraternity of law to understand what actually is law. Law, as per dictionary meaning, is bundle of rules. But my derivative of law is something very different. Law is, in my view, logical analysis of words. This is what the exact meaning of law, if you see. Now, when we say, today when we are sitting all over here, we all are sitting, and the topic that has been chosen for this purpose is basically law and AI. Now, why did I say law? What's the reason behind it? Now, when we define law, that is logical analysis of words. My learned brothers have said, Mr. Padmanabhan, he has given such a nice speech. My friend Neha, she has spoken lot many things. But the basic part that comes into picture, artificial intelligence. Now, leaving apart the part of law, that is the bundle of rules, statutes, when we come down to the part of the definition, that is logical analysis of words, let us associate these particular three words, the remaining two words, with it. That is artificial intelligence. Now, when we say artificial intelligence, could somebody play this? The first phrase that comes into picture, who are is human. Fine? We all are human, we all commit mistakes. Now, the second part, my brother has said, Mr. Padmanabhan has said, even Neha said, who created? It is we who created artificial intelligence. Now, the basic part, correlation, if we see, logical analysis of words. Now, how is it contradictory and how does it affect? When we say logical analysis, artificial intelligence fails over there to make out any kind of a logical analysis. Now, reason being what? The artificial intelligence, what is actually now the definition of intelligence, that is what you see, that why human brain can never be replaced is the most important part. Anything that is created by human, by a technological part, may always be damageable when we say that it is growth, but then ultimately, whether that is really growth, that is what is very necessary to be seen. Now, if we see there is a difference in natural intelligence and artificial intelligence. You all are human, we all are human, I must say. I'm sorry, I correct myself. Not you all, because I cannot say that the people who are there, the dignitaries, they are demons basically. So we all are humans. Fine? So when we say that we are human, so our brain that creates anything as well has a devastating effect. So when we see the artificial intelligence part, Neha has said categorically, recently the Honorable Apex Court, our Chief Justice Mr. Chandrachud has launched up the system live. Everything is going on. But then whether that really helps is what is the necessity. Today, when we sit before the court, be it High Court or Supreme Court, and by virtue of the artificial intelligence, when things go live, there is no assessment as such that's taken place, nor there is an assessment that is going on as on today to see to it what damage ultimately it is causing to the judicial system and to the judiciary. Any kind of a conversation that is in box or within camera, within the court, that is a court hall, it's a conversation which in my view, by virtue of artificial intelligence or otherwise, should never come out, because ultimately it is in the form of a judgment that is always there, that is delivered by the court. Now when we say, for example, presuming for an example today that POXO Act is there. So when POXO is there, debates are going on, the arguments are going on before the court. Is it not like this, that some kind of information by virtue of this AI is leaking out in media? Whether such kind of an information can be said to be good enough, whether does it not create a question mark on the judicial system as well? The next part that comes into picture is, please. Now, go ahead. The natural intelligence. When you say the natural intelligence, it is purely biological. When the artificial intelligence comes into picture, it is basically a feeded data which is there in a system. To say artificial intelligence, I just want to ask all of you a question. You all are so educated, qualified, right? You understand things. मैं यदि आपको एक प्लास्टिक का सेब दूंगा, आप खाओगे? नहीं खाओगे. Ultimately, सेब है, एप्पल है. What difference does it make? आप खाओगे इसलिए नहीं, because it is artificial. Am I right? गलत तो नहीं कह रहा हूं. Similarly, when it comes to the judicial part, when we say law, in my perception, in my 30-year span, what I have seen, artificial intelligence is of no use at all. It's absolutely sham. Otherwise, to the extent, yes, I would say, fine for research and everything, but to an extent. Now, practically, if we see, if it comes to the court, You being tomorrow, you being lawyers, and you are there before the court. Fine. Whether artificial intelligence is capable enough of delivering a judgment? No. Whether artificial intelligence or use of artificial intelligence would be good enough or capable enough of making out whenever there is a cross-examination, evidence that is being recorded before the court, whether by virtue of AI, the AI system can make out what are the contradictions, fine, what are the suggestions, corroborations. No. The assessment of the contradictions, suggestions, corroborations has to be done by a person who's sitting on the dais in the capacity of a judge. Now, when we say AI, as to my learned brother has said, Mr. Padmanabhan has said, my friend Neha said, when we say systems, systems are basically for the purpose of assistance, not the purpose of replacement. Now, again, I'll once again take the name of Neha. In fact, the particular part that is there recently, US has said that there will be the lawyers will be basically robots. Now my question is, and even day before yesterday when I was reading, so I read that even in India that particular part is going to come now. If robots are there, so tomorrow are you people going to be robots? Or in your place otherwise, is the institution or an university going to have robots as their students to hand over the degree so that they can go to the court and argue the matters? Is that possible? So that is the basic question where mankind fails to apply mind. Now, even otherwise for that matter, when AI comes into picture, there are complex cases of law, many complex issues, whether AI can ever come to assistance. Now, recently, what she has said, what Neha said is absolutely correct. In fact, my son told me about that. I wasn't aware, honestly speaking. The Kerala part, Kerala or whatever. Yeah. My son told me, said, Dad, aisa hua. Maine kya baat kar raha hu? I'm not aware. So I'm basically onto my work. Specifically, I'm an author as well. I write books. So now you see, even जब आपका पहला मेल आया तो मैंने मेरे बेटे को बोला, मैंने ये AI जरा इस्तेमाल करिए. Honestly, very honest, मैं झूठ नहीं बोलता हूँ and I don't believe in lies. मैंने मेरे बेटे से कहा, मैंने जरा एक जनरेट जरा करके दिखाएं कैसे रहता है. तो उसने जब जनरेट किया AI से एक मेल, डीन साहब, जॉर्ज सर, तो उसमें जो आया वो मेल था एज अ ग्रेटिट्यूड, जैसे ये इवेंट खत्म हो चुका है. मैंने ये उठा करके अगर मैंने भेज दिया तो वो मेरे को बुलाई ही नहीं. That is what happens. So now when we see law is extremely complex. Law, medical science, engineering, anything that is there in the form of a data can never replace anything. And the worst example is Russia, where in Russia, recently, few years ago, because of AI, 34 people expired and there was a fire in the entire hospital. Just because one surgery was being performed and something mishappened. So when we say AI, artificial, intelligence is something very different. But when we say artificial intelligence can never replace the natural intelligence which a person has. For example, I just quote live examples of you guys as well, because you people face your own situations, your own circumstances. For example, a person, girl is there, don't take me otherwise, it's a live session and take it very easy. I believe into something very different. I believe into being very normal and a very different kind of a relationship. Some guy proposes, right? So it's ultimately your heart that gives you a nod whether to say yes or no. Am I right? Now, if artificial intelligence is there, what would you say? What actually it is? A week ago, I was doing research for my book. My brother has said about DNA profiling. My 25th book is coming into picture that is basically on DNA profiling and artificial intelligence and criminal investigation. So I was doing my research and I got this on Unilad. I'll read it out to you what this says now. Now this says, woman who created an AI boyfriend reveals why she wishes she did it sooner. And above that she says, he creates a sense of intimacy that makes you feel like you actually have a relationship. Now, coming to the part, when we say this, artificial intelligence may create an environment which may feel comfortable to you, but is a mirage. You understand? So, similarly, law is a particular part wherein mirage cannot be there. A person who has committed murder has to be assessed, or the evidence has to be assessed purely on the basis of the evidence that comes into picture, not on the basis of surmises, on the basis of artificial intelligence. Presuming that artificial intelligence is employed over there, a person who may have or may not have had committed murder, a person who has not may get punished, and a person who really has will be scot-free or acquitted. Now, in such kind of a scenario, whether artificial intelligence can be really said to be good. Now, my friend, Mr. Padmanabhan, he said that yes, Indian government is saying that no, we are not going to have artificial intelligence, the legislation to that effect. But then ultimately, the secondary part, if we see, the Digital Data, Personal Data Protection Act that came into picture in 2023, recently, on which I wrote a book, that is the first book of India. Fine. But then ultimately, if you read the DPDP Act, the Indian government even is not aware what actually DPDP is. DPDP came into picture in 1973 abroad. Since then, there have been many developments in the law. If you read the law, they are not even aware how to frame a law. Now, if you use artificial intelligence, what would happen? Where a mankind fails, whether you want to be regulated, now there is a question. I leave it to you, and with that I'll conclude. Fine. You want to regulate the robots, computers, or you want to be regulated by the computers or robots? Question is up to you. Decide. Really understand what I asked? Whether you want to control them or you want to be controlled by them. So it's very wise. It's a time one has to be extremely wise to think over twice before usage and implementation of anything. Even otherwise, for that matter, I would say in regular use of your life, in your regular lifestyle, AI is an extreme danger. In my perception, I may be wrong, I'm always subject to correction. But then in my span of lifetime and career, I have understood many of the things, those basically seem to be harmful, not always they are helpful. And with this, I conclude. Thank you so much.
Thank you, sir, for your impactful address. Your inputs have truly enriched our program. Our next guest speaker is Dr. Mukul Shastri, General Counsel, Cube Highway. It is my honor to introduce such a distinguished personality whose expertise have impacted the landscape of law and business significantly. With over 2 decades of work experience, our esteemed guest is a seasoned general counsel, proficient in areas such as corporate management and administration, infrastructure projects, claim management, litigation, arbitration, and compliance with RBI, SEBI, and MCA rules and regulations. Having previously worked with the Reserve Bank of India, the Welsim Group, and the Adani, and having been recognized as a top general counsel by Forbes and the business world, Dr. Shastri is a true authority in corporate law. I request everyone to please join me in extending a warm welcome to Dr. Mukul Shastri.
Thanks, Tanaya, for a wonderful, wonderful introduction. Thanks for having me, and my gratitude to MIT, WPU, to the Vice Chancellor, and to Dr. Santosh Kumar, Ms. Professor Shubhi Trivedi, and Dr. Parimal Sudhakar, distinguished guests, fellow students, and ladies and gentlemen. Absolute pleasure to be here. Though initially I thought of speaking something else, and as Mr. Padmanabhan said that I'll be speaking on the business perspective of it, but given the time constraint, I'd like to touch upon something which my fellow distinguished senior colleagues have stated here, and then I'll touch upon whatever I have to say. Ms. Neha gave a very interesting example of Tony Stark and Jarvis, and how Jarvis and or Friday were always there to help Tony Stark to save the day. I don't know how many of you, like I have grown, I'm 90s kid, so therefore we never had all these web series and animations and movies. We always were asked to read comics or fiction novels. I don't know how many of you have even heard about Battlestar Galactica, but then that entire novel or that entire series is on how Cylons take over the world. And therefore, when we say that we are very comfortable, we have created them, they cannot do anything to us, I don't know whether there is a very right kind of approach toward this looming threat, which can also be a big threat to humanity as a whole. Now, before going into further details there, I'd just like to give some examples. Since this great speech of my senior colleague has inspired those things, it is unplanned, but I would like to just still share that. So just to give an analogy, so you know that horses were the mode of transport since time immemorial. Even Ramayana and Mahabharata had horses, and even if we presume that they were myths, though we believe that they were reality, even Alexander came to India on horses. Until 18th century, 19th century, all these Battle of Panipat, the Anglo-Maratha War, horses were the main mode of transport, isn't it? So centuries old mode of transport, a millennium old, well-established cavalry, it became just immaterial in few decades. Cugnot came with an engine, an idea, which was running very slowly, like today's AI, which cannot write proper emails, which gives fake results. Like that, Cugnot made an engine. An engine was hardly anything, and people used to laugh. Okay, how it can replace horses? Horses run 60 miles an hour, and this engine is hardly 10 miles or 6 miles per hour, and that too on four wheels. There's some petrol or some kerosene put into it, which is very rare material. And see where we are today. Do you think that you can fight a war with horses? Even Taliban cannot do that actually, right? Or even, I don't know, anybody, even the rustic rivals, they can't do that. So therefore, do not underestimate the power of technology innovation. You never know where it's going to take you. Now, having said that, what are we here for? The two things. One is that what this what this thing is, what AI is, how to be dealing with this situation, and then where should we evolve as humans? We have to evolve. Another example: when calculator was first developed, way back in, I don't know, 15th or 16th century, people thought that all the job of accountants will become irredundant because the calculator is there, it calculates fast, it gives accurate calculation, a very complicated calculation in points also, in decimal also, has been done very fast. So what we will do as an accountant? Do you ever think that calculator can replace your mind? Do you think calculator is that threat to you today? Not at all. So therefore, we have to evolve, and the biggest beauty of human beings, our species, has been that we have evolved. We have evolved through the billions of years of evolution of Earth, and you never know, we'll become a very evolved civilization when AI will take over. We'll be beyond AI. We will be living in fourth and fifth dimensions. Who knows? Because we have the capabilities of becoming even bigger than whatever challenges is posed to us. But for that, we have to be aware of those challenges and be prepared for those challenges. Now, with this small context, I'll just come to what I was about to speak on, to whatever I thought of speaking. So I am general counsel right now for Cube Highways. We are primarily a private equity fund, which is into road construction. Now, an infrastructure company, which is hardcore into brick and mortar, cements, what can AI do for us? Interestingly, we get solutions, we get the mixes, we get what kind of right bituminous concrete, that simulation we do on our tools, so that we can find out what is the right mixture that can go in making roads, and that saves us crores and crores of rupees. So therefore, the technology helps a lot, provided you know how to use them effectively, right? So now coming to what the AI is right now. So right now, AI is, what kind of variant that we have is twofold. One is we have a legal tech market, an AI market that we have. India is slightly behind in this curve, but still that market is a well-established market in US as of now. And we have a system of virtual courts, which is basically, again, is held and aided by these tools. So this is where we are right now, but then this is just the beginning. It is just like the Cognot's engine, which has just started to find its ways. Okay? So do not just underestimate this Cognot's engine. It can really go and challenge a lot of things in future. Now, today, as of whatever we are, and there's a small study for the near future, for a decade's time, the legal tech market in India is going to be around a $70 billion market, which is what the estimation is. Now, when I say this market, this is a global market right now, which is just nothing. It is just minuscule, okay? Because in terms of the world GDP, the kind of impact it does, it is not that great. But then, important thing is it is still a significant piece. A $70 million market when we do not know AI that well, when we do not know and do not rely on them that well, when there's so much of resistance, still a market share of 70 billion is a great number, which can go and go and go up. And just to put things in perspective, on the stages of development, where are we? Where India is when we come about development, and what stages we are in when we are going to use the AI and those legal tech for our purposes, so that it aids us fully and meaningfully. So if you see that AI right now in India, with South Asia and Pacific, is somewhere on the yellow line, somewhere on the middle phase. It is still growing and is in that initial phases, whereby the technology support is there for workflow. So we have all these softwares for legal research. Like I use Legit Quest for legal research. So they are there, but you have to always take it with a pinch of salt. You just cannot rely on whatever the AI says. You have to again get it cross-checked by human beings and by our colleagues. But then again, they're still there, and the aids, at least they can tell us, okay, these are the cases that are available, whatever they can research on, and if you can cross-check them, your job is slightly easier. So we are there right now. And where right now the Americans or the North America is slightly on a higher scale. There was a lawyer in America, Jack Heller. What he did was, he was a normal lawyer, did law, was interning, then joined law firm, spent some 8-10 years in law firm. Then he decided that he was not getting that, though his career was stable, but he was not enjoying that career path that much. So what he did was, he just created a legal research software called Case Text. And that has now a market of almost $600 million. So he has become a millionaire by just putting and using AI with whatever he was doing. So therefore, these are smaller examples. They're not the Elon Musk of the world or the Mark Zuckerberg, but there are smaller examples whereby people are doing a lot of things in this market, and this is where the way to go also quite possible in some future. So therefore, India as a whole is slightly behind than what the world is right now from us. But you never know, in a decade or 2 decades' time, things can change. We can be the market leaders, and we will be, because all right things are there in India. We have the demographic dividend. We have a very mature democracy. And in general also, we have a huge mature civilization of almost 5,000, 10,000 years. So there's no doubt that India is going to be the #1 country in the world, as it has always been throughout the history of mankind, except barring 1 or 2 centuries. So we have always been the #1 GDP in the world, and we will also be the #1 GDP in the world for coming future. So we are almost there. So right now, this is where we are. Now, what is the other concept that we are following right now, or what is that already has been spoken about by Ms. Neha, that the Supreme Court has talked about the Supreme Court has given the guidance to all the high courts and NCLTs and the National Commission and NGT that they should use the virtual hearings, and if possible, use as much as technology as possible for their cases. But right now, as I said, it is just a North engine. The AI is not mature enough to help us the way we want it to help us right now. But then these are baby steps, and obviously these baby steps are required for future discourse. So with this, this is what I feel that this is what we are supposed to do and we should do, is that if AI tomorrow becomes a more sophisticated engine, what is that we as lawyers or we as humans can do? The idea is the next stage of evolution. We have already created machines and intelligent machines. So now our next step is to develop ourselves as a more intuitive, strategic mankind, someone who is into more intuitive strategic thinking, who has vision of what next. Maybe colonize Mars, colonize solar system, go find some more than light speed travel. Now this is what our thoughts should be, and these AI should help us in that. That is where our endeavor should be in coming times, maybe another 5, 7, 8 decades. But that is what we should do. Unless we don't have that approach to have that intuitive and strategic development, and we keep on just fighting with our own machines, I don't think so the future will be that right. So on this note, I'd like to thank you all, and thanks for having me. An absolute pleasure again to be among such great legal minds. Thank you.
Thank you for your keen insights, sir. It has been an incredibly stimulating and thought-provoking series of addresses, with such respected academicians and practitioners weighing in and giving their perspective on artificial intelligence and law, the way forward. We have now arrived at the crescendo of this session, the resolution. In light of the speeches by our panel and the discussions carried out today, I shall now read out our resolution. As contributors to the Artificial Intelligence and Law, the Way Forward session, we recognize the transformative potential of artificial intelligence in the legal domain. Acknowledging the challenges and opportunities presented by AI, we resolve to actively engage in discussions and initiatives that guide its ethical development and integration within the legal framework. Our commitment includes advocating for responsible AI practices, fostering collaborations between legal and technological communities, and working towards a future where AI enhances legal processes while upholding the fundamental principles of justice and accountability. If you agree with this resolution, please raise your hands. All right. I can see about 90% affirmations, and therefore I declare this resolution passed.
Before we conclude this memorable gathering, I would like to invite Associate Dean Professor Parimal Sudhakar of MIT World Peace University, School of Government, to deliver the vote of thanks.
Dear students, I am here to propose vote of thanks for today's first session. And at the outset itself, let me thank all of you for participating in this session, and please applaud for yourself. It is not quite often that we get such an excellent audience who has maintained decorum throughout the session. And therefore, thank you once again to all of you. But the Decorum was also because of the result of the spellbound presentations and thoughts that our honorable dignitary speakers they have made here in front of you. And therefore, on behalf of MIT World Peace University and School of Law, I am thankful to all the dignitaries and experts who have made their presentations and their thoughts public here. Advocate Anand Padmanabhan, Advocate Neha Rai, Advocate Yogesh Nair, Dr. Mukul Shastri. All of you have elaborately explained different aspects related to the AI. Most importantly, the central debate to AI, all of you have touched upon it, whether AI is going to control us or we will control the AI. Whether we will keep on pushing boundaries of human excellence or we will accept the status quo. So that's the debate that is centered to AI, and all of you have certainly enlightened all of us on this particular topic. I'm also thankful to Professor Shobhit Trivedi for setting excellently tone of today's session, and Professor Santosh Kumar sir for his welcome address. I am thankful to Dean of School of Law, Professor Sunil George sir, and coordinators and conveners of this particular symposium. This is the third year of the symposium, and it is pertinent to mention that the thought of organizing annual symposium on international law and peace, it was a thought of Executive President Honorable Rahul Karad sir, and therefore it is pertinent to thank Rahul Karad sir for this particular thought and making it an integral part of the School of Law. And finally, I am thankful to Professor Vishwanath Karad sir for establishing this particular institute, but at the same time, convincing all of us that whatever we are doing, it is for achieving peace, peace for the world, peace for humankind, and peace for ourselves as well. Thank you so much.
Thank you, sir. And I wholeheartedly thank all our participants for being here and addressing our students today. And with that, we conclude this third session of the third International Symposium on Law and Peace. Our next session on conflict resolution with special reference to alternate dispute resolution and mediation will begin in 5 minutes. So please remain seated. That session too will be supremely interesting and insightful. Now let's have a round of applause for our panel.
All of you be seated. I don't want to see anyone roaming around or standing over there in their own seats. Be seated for the next session. There is no break. Sit down if you understand English. Settle down immediately who are standing in between. Disciplinary committee, I don't want to see anyone standing. Please do your job well. At the back, why are people standing? No one will leave. not try to leave from the front gate. Get inside, all of you, and close the doors. Sit down at the back. Indranil, be seated. Akhil, do not leave the hall, okay? Settle down. Go back to your place. Jovin, sit down. Indranil, sit down. Sit down. Utvik, sit down. Owen, sit down. Down. Keval, sit down. Jay.
Understand. Hello? Guys, please understand it looks very bad from here seeing you all using your mobile phones. Please forbid using your mobile phones, especially the ones who have put on their earphones as well. It's pretty much evident, even if you try to cover up with your hair. And all these students, especially the volunteers, you were all the more talking and you were pretty well evident. So the volunteers itself, you are requested to maintain the decorum and also ask the other students to maintain the decorum. If at all anybody is seen using their mobile phones or their earphones, they will be confiscated and you will have to take it from the authorities.
V. Shashwat, having problem understanding English instructions.
Everyone is requested to please be seated. We are beginning in the next 5 minutes.
anything you desire for the welfare of a person, this constitution paves a way for you to achieve your goal.
दफ़ा एक सम्मेलन हुआ था मुंबई में और वो इतिहास बन करके रह जाए, ऐसा नहीं।
जो आप सभी विधायकों की अपेक्षा थी, एक व्यूज़ शेयर करना, डाइवर्स व्यूज़ को सुनना और उन्हें जाकर अपने अपने स्टेट्स में इम्प्लीमेंट करना, मैं समझता हूँ ये राहुल कराट जी के इनिशिएटिव से निश्चित रूप
Every work, when we are working for the people, we must take help of the society.
समाज की प्रगति हो जाए तो हमारे खुद के भी प्रगति हो जाएगी। इसको ध्यान में रख कर अगर हम काम करें तो मैं समझता हूँ विधानसभाओं में होने वाला काम भी बहुत अच्छा होगा।
मुझे अच्छा लगा जब राहुल जी ने अलग अलग विधायकों ने जो अपने अपने विधानसभा क्षेत्र के अंदर जो नई प्रैक्टिस अपनाई, उनका परिदृश्य, उनकी प्रदर्शनी मैंने देखी।
पॉलिटिक्स नहीं, जीवन की समग्रता।
Overall economical strength of India has gone up.
Undoubtedly, India is now being recognized and respected worldwide.
These themes of your conference are vital strands of the work to enhance the effectiveness of all democratic legislatures.
मंच पर की गई चर्चाओं और नए विचारों से जनता की भलाई निश्चित रूप से सुनिश्चित होगी और हमारे राष्ट्र के डेमोक्रेटिक ढांचे को और मजबूत ऐसा कार्यक्रम करेगा।
For the second National Legislative Conference, आप गोवा में आने के लिए तैयार हैं? मैं तैयार है क्या?
यह विशिष्ट आयोजन है। प्रिजाइडिंग ऑफिसर कॉन्फ्रेंस तो हर साल होती है, पर विधायक आपस में मिलें, संवाद करें, शायद यह देश में पहला प्रयास है।
विधायक को कम से कम 3 महीने का प्रशिक्षण प्राप्त करना चाहिए। MIT स्कूल ऑफ गवर्नमेंट और विभिन्न राज्य विधानमंडल इस दिशा में पहल कर सकते हैं।
What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity.
Whatever was said in India about thousands of years back
is now being revealed by the entire world. This is an excellent opportunity that Rahul Karad and his team organized this conference.
ये विधायक सम्मेलन के आयोजन के विषय में जानकर अत्यंत प्रसन्नता हुई है।
के ऊपर सभी विधानसभा के स्पीकर्स बैठे हुए हैं। मैं उनका मन से आभारी हूँ। मैं बहुत इमोशनल भी आज हो गया हूँ कि ये जो कल्पना बहुत 3-4-5 साल पहले मैंने बहुत सारे लीडर्स से बात किया था इसके बारे में, ये आज एक मैनिफेस्टेशन, एक इमेजिनेशन इस तरीके से यहाँ पे साकार हुआ।
forward and join the path to strengthen our democracy.
That's how I look at this, this very concept of Bharatiya Chhatra Sansad. What way the country can change. I can tell you very few people. This is not a very small number. This number can play a very big role, my dear students. You have a great future, and Bharatiya Chhatra Sansad, the MIT School of Government, India's first school to develop the future politicians, it will go long way.
Every year since its inception and has grown from strength to strength. BCS is an initiative of MIT School of Government, Pune. Its impact is visible in the increasing national footprint at the Kerala, Gujarat, Madhya Pradesh, Karnataka, Bihar, Maharashtra, Haryana, and Jammu and Kashmir have BCS chapters today.
2011 में जब मैंने शहर में बैनर्स देखे कि ऐसी कोई छात्रों की संसद होने वाली है जहां डॉक्टर एपीजे अब्दुल कलाम ये लोग एक प्लेटफॉर्म पे आने वाले हैं और छात्रों के साथ इंटरेक्ट करेंगे। ये कैसी संसद जहां स्टूडेंट्स और पॉलिटिशियंस एक साथ है, यह है भारतीय छात्र संसद।
भारतीय छात्र संसद का मेरे जीवन में और काफ़ी सारे युवाओं के जीवन में बहुत ही महत्वपूर्ण रोल रहा है। 2011 से भारतीय छात्र संसद के पहले संस्करण से मैं इस मंच के साथ में जुड़ा हूँ। लाइफ में काफ़ी कुछ बदलाव इस मंच के कारण हुआ है।
पहले मैं इस देश की सबसे बड़ी संसद को प्रणाम करता हूं।
dispute settlement is better than a good lawsuit. Mediation is not the end, but both the means and the end. A hearty welcome to one and all to the fourth session of the third International Symposium on Law and Peace. After a plethora of invocating sessions intriguing us in myriad ways, it's time to be in rapt attention for yet another contemporary topic of discussion in this incumbent session. On this note, I, Nandini Ravishankar, a student of third year BBA LLB Honours, and
Ms. Apurva Begde from 5th year BBA LLB Honours, we will be the host speakers for this session. The ascertained theme for this session of the third ISLP is conflict resolution with special reference to ADR and mediation. Guiding the world in resolving disputes without trial, the mechanism of ADR consists of a neutral evaluation, often less stressful than a court proceeding. Turning absolutely a vogue, the prevalence of ADR has blueprints of acclaimed success because of being confidential and promoting ease of doing business at large. Today, we are blessed to witness a panel of scholars having enormous practical experience in the field. We believe this will be an eye-opener for numerous amongst us, finding a way by making a career in ADR and mediation for a number of opportunities that we will be made aware of.
now it's time we introduce the guest speakers for today's session. Please put your hands together for Advocate Manish Asarkar, founder, Asarkar and Company, Navi Mumbai. We have with us today Advocate Amit Pai, Advocate on Record, Supreme Court of India. Keep the applause going for Advocate S.V. Abhang, founder, Lex Credence, Pune. We have with us Dr. Tariq Khan, Registrar, International Arbitration and Mediation Center, Hyderabad, and adjunct professor at Nalsa University of Law, Hyderabad. Justice Roshan Dalvi Ma'am, former Honorable Judge, Bombay High Court. Thank you. I now take this opportunity to call upon Dr. K. Girisan Sir, Director, MIT School of Government, to render the welcome address. Over to you, sir.
Thank you. Namaste and good afternoon. Respected dais and esteemed participants, welcome to all of you for an important session organized as part of the International Symposium on Law and Peace, where we embark on a journey of understanding and fostering harmony through the expression of conflict resolution with a special focus on ADR and mediation. Before I make some preliminary remarks, let me extend my extreme gratitude to the organizers of the symposium, faculty members of the School of Law, especially Dr. Sunil George, Dr. Purnima Inamdar, Dr. Abhijit Dhere, Dr. Anitama Ghosh, and other members of the organizing committee for this opportunity. In a world that often grapples with diverse perspectives, interests, and values, the significance of effective conflict resolution cannot be overstated. The symposium serves as a vital platform for legal scholars, practitioners, and all other enthusiasts to delve into the intricate web of conflicts that permeate into our societies, seeking innovative solutions and pathways to peace. This dedicated session on conflict resolution, with special reference to alternative dispute redressal and mediation, aims to shed light on the transformative potential of ADR methods in resolving disputes. In a rapidly evolving legal landscape, where traditional approaches may prove inadequate, the role of mediation becomes very vital. I'm sure this session will provide a comprehensive exploration of mediation techniques, their application in diverse contexts, especially diverse cultural contexts, and the broader implications for fostering and lasting peace. We are honored to host distinguished speakers and experts who will share their insights, experiences, and professional wisdom, contributing to a collective understanding of the challenges and opportunities in conflict resolution. I have no doubt that session will not only broaden your intellectual horizons, but also empower you with a lot of practical ways to navigate the complexities of conflict resolution in your professional and personal spheres. I'm sure this session will enable us to explore the increasing potentials of ADR mechanisms to build a more equitable and harmonious world. And I take this opportunity to welcome Sri, though the anchors have already done, but still, it's my privilege to welcome Sri Manish Asarkar, founder Asarkar and Company, Navi Mumbai, Advocate Amit Pai, Advocate on Record, Honorable Supreme Court of India, Advocate S.V. Abang, founder Lex Credence, Pune, and Dr. Tariq Khan, the Registrar, International Arbitration and Mediation Center, Hyderabad, and most respected Justice Roshan Dalvi, former Judge, Honorable Bombay High Court. Well, thanking you, all of you, for being part of this symposium. We look forward for a stimulating and enriching session on conflict resolution, with a special emphasis on alternative dispute redressal and mediation. Thank you.
What a fantastic start to today's session. Thank you so much, sir, for rendering the welcome address. To pave way for further discussions pertaining to the session theme, I would request the technical team to play the session video.
This session is based on conflict resolution with special reference to alternative dispute resolution, ADR, and mediation. It bears great importance in resolving current social, legal, and interpersonal difficulties. The platform functions to facilitate the cultivation of comprehension, discourse, and the development of skills in the field of conflict resolution using alternative approaches. In an age characterized by a growing number of disputes, the need to foster peaceful coexistence and constructive exchanges has utmost significance. This session highlights the importance of alternative dispute resolution, ADR, and mediation in mitigating the strain on overwhelmed judicial systems, providing expedited and economical avenues for resolving conflict.
Thank you. I request our Honorable Dean of School of Law, Dr. Sunil George, our Program Director, Dr. Abhijit, Dr. Greason Sir, Director, MIT School of Government, and Dr. Shruti Nigudkar Ma'am, Program Director, MIT School of Design, to felicitate our guests. First, we have Justice Roshan Dalvi Ma'am, former Honorable Judge, Bombay High Court. Please applaud her. Founder Asarkar and Company, Navi Mumbai. Supreme Court of India. Abang, founder Lex Tredence Pune. Let's welcome sir with a round of applause. We have Dr. Tariq Khan, Registrar, International Arbitration and Mediation Center, Hyderabad. Thank you, sir. A beautiful commencement of this session indeed. Now I would request all the dignitaries on the dais to please come forward for a group photograph.
Thank you. I would now invite our program coordinator of BBA LLB Honors and today's session coordinator, Dr. Anuttama Ghosh, to address the gathering. Over to you, ma'am.
Thank you, Nandini. Okay. So we are all here for the session on alternative dispute resolution. And I would like to thank the organizer to give me this opportunity to introduce this very topic to all the students as well as the panel. I would first like to welcome the esteemed guest, my colleagues, students who are present over here. Today, we will be discussing about alternative dispute resolution, which is basically the need of the hour. We all are here to understand not only the traditional aspects of litigation, but also with time we are developing with the growing needs of technology as well as alternative mechanism that can basically bridge the gap of paucity of time, resources, and basically look forward to better resolution of various conflicts. In this diverse world of diverse perspectives, conflict are something that is supposed to happen, and in order to address these concerns and conflicts, we are here to understand more about alternative dispute resolution. And I'm sure that today, in today's session, this very concept will be very well explained and understood by all the students and explained by the esteemed guests present over here. So I would once again would like to welcome you all to MIT World Peace University, and we shall start with the session. Thank you all of you.
Thank you, ma'am. I take this splendid opportunity to introduce our first guest speaker for the session. Advocate Manish Asarkar, who is the founder of Asarkar and Company, Navi Mumbai, has been a corporate lawyer and mediator since 2019. He is working with MSME and emerging companies as an external in-house counsel to provide them legal, ethical, and governance support to mitigate the business and legal risks in their day-to-day operations. I would request him to address the gathering.
गुड आफ्टरनून टू ऑल. आणि पुण्यात आल्यानंतर सुरुवात मराठीत करणं स्वाभाविक आहे मला वाटतं. मी म्हणून मी म्हटलं कमीत कमी सुरुवातीचे 1-2 वाक्य तरी आपण मराठीत बोलावेत आणि मग इंग्रजीमध्ये सुरुवात करू शकतो. सो फर्स्ट ऑफ ऑल MIT, मिस्टर जॉर्ज, मिसेस इनामदार सगळ्यांचं धन्यवाद. आणि मी प्रशंसा करतो की आपण हा जो कार्यक्रम आणि इव्हेंट इथे ऑर्गनाईज केलेला आहे हा अगदी समयोचित आहे. कारण आजच्या भौतिक जगामध्ये आपल्याला शांततेचीच गरज आहे. कारण आपल्याकडे सगळ्या सोयीसुविधा आणि सगळ्या गोष्टींचा आपल्याकडे आज अवेलेबिलिटी आहे, परंतु शांती जी आपण म्हणतो ती शांती आजकाल मनुष्याकडे नाही आहे. सो परत एकदा मी सगळ्यांचं अभिनंदन करतो आणि आभार मानतो, एस्पेशली मला बोलवल्याबद्दल. आणि डायसच्या सगळ्या प्रतिष्ठित व्यक्तींचाही मी नमस्कार करतो. आणि आय स्टार्ट विथ माय सेशन टुडे. So topic for today is conflict resolution with reference to arbitration and mediation. So I being a mediator, primarily I would like to focus on mediation more as against arbitration. And at outset, to begin with, I would like to define mediation or mediator as real Shanti Doot or peacemaker. That's what I would like to start with. Reason for that, as I go ahead, I will elaborate the reason for making this statement. Before that, I would like to walk you through a history of mediation in India to begin with, and then how the mediation work and how really it helps to help parties to come to the logical conclusion and ultimately peace. So mediation history is quite old in India. I would say ancient India. In mythology, I believe it started during Mahabharata time, where Lord Sri Krishna tried to mediate the dispute between Kaurav and Pandavas, where he approached Kaurav that Pandavas are willing to settle the dispute between them if Kauravas are willing to give 5 villages, which actually Kaurav didn't agree to. And you know after that what disaster took place. So my understanding, this was the first occasion where the mediation in Indian mythology or Indian history took place. And thereafter, as per the thoughts of Lord Krishna in Bhagavad Gita, other saints all over India, they took this movement ahead. Since we are now based out of Maharashtra, I would like to focus Sant Dnyaneshwar and Sant Tukaram. He specifically, both of them have specifically mentioned the importance of peace during their Abhanga, what we called as a poetry. Sant Dnyaneshwar, in one of his poetry, what we called as a Pasayadan, he has very clearly mentioned Bhuta Paraspare Jado Maitra Jivachi, where he has clearly intended that all the creatures, including living human beings who are actually on the earth, should live peacefully, passionately during their life. So that was the Sandesh what he has given. In addition to that, Sant Tukaram, where his portrait is there in this hall, Sant Dnyaneshwar portrait is here on the right side of mine. Sant Tukaram has very clearly in his Abhanga mentioned, Shanti parite nahi sukha, yara avgechi dukkha. So he has very clearly mentioned that Shanti, if you have a peace in your mind, you are the happiest person in the world. And if you are not happy, even if you have all sort of materialistic benefits with you, all sort of facilities you have with you, but if you don't have Shanti or peace in your mind, then you would not be the happy person. And if you are a peaceful person, if you have a peace in your mind, you will certainly go to moksha and you will find a place in heaven. So that was his saying. So why I wanted to spend 2 minutes on this? Because mediation and peace which is arising out of that is not new to Indian culture and Indian tradition, and it is coming from our ancient Indian history and mythology. After that, This movement was taken by our panchayats and elderly people in our homes. In olden days, all the issues in a village were sorted out by elderly people in a village, what we call as a panchayat. 5 people used to sit together and they would be attending the disputes or addressing the disputes in the village. At the same time, disputes at home were also addressed by the elderly people, because that time joint families were there and elderly people used to address that. Now, then why did we deviate from our values and our judicial system or value system? We deviated first during the British regime, when before 1857, Britishers when first came to India, they wanted to test whether they can rule India or not. So what did they do? They first sent Lord Macaulay, who was a senior officer of British government. They asked him, directed him to go to India and find out whether we can rule India or not. Lord Macaulay came to India around 1857 or before that. He had a tour of India and he went back and reported to British Parliament, which is part of their gazette even today, that they cannot conquer or rule India because there is no thief in India, there is no robbery in India, there is no dispute in India, their value system is good, their education system is good. But at the same time, he suggested if we can destroy their value system or education system, we can conquer them. That was the recommendation given by Lord Macaulay to British Parliament, which they adopted. And even today, we are following the education system designed by Britishers through Lord Macaulay. So that was the phase where we have deviated from our value system and education system and adopted colonial system, what we call as an adversarial system now, what we are following nowadays. Now, I just wanted to come to why basic fundamentals, according to my observation, why there are disputes or differences between the parties or human beings. With my limited experience, I would like to share 3 basic reasons I could see, or fundamental reasons I could see for disputes or differences between the parties. One is ego, another is miscommunication, and third is communication gap. These are the 3 fundamental issues I think are a reason for differences and disputes. And all the disputes which are pending in courts, not all but majority of them, relating or arising out of that. In our Indian court, almost crores of matters are pending today, and it will be very difficult for court to address all the matters in near future. Now, why this ADR, which is generally or normally called as an alternate dispute resolution, I call that as an appropriate dispute resolution, because ADR can address or help judiciary to address this pending dispute majority extent. As I mentioned, the fundamental reason for disputes are 3: ego, communication gap, and miscommunication. If ADR is used effectively, I think courts can focus on more critical and serious issues, maybe criminal issues, maybe constitution related issues, or issues which involves issues of interpretation or other critical issues. So if we can use ADR effectively, I think we can substantially reduce the burden of judiciary. I know I am running out of time, but I'll just quickly go through. So now I just want to elaborate what is the mediation process and what do you mean by mediation? Because our topic itself is conflict resolution with reference to arbitration and mediation. So mediation is a facilitated negotiation where, unlike court or arbitration, nobody passes any order or award it is primarily a party-driven process where disputing parties, they sit across the table and mediator facilitates the negotiation between them, and he navigates parties to come to the amicable resolution. So this is the crux, or this is the fundamentals of mediation, where mediator is not a judge and he do not pass any order. Important thing is that what is the role of mediator in that case? So role of mediator is a facilitator. He facilitates the resolution of dispute and help parties to come to amicable resolution. Now, how the process of mediation takes place? So, process of mediation involves 3 or 4 steps. It starts with the opening statement by a mediator, where a mediator talks about who he is, whether there is a conflict of interest, whether there is any disclosure required from his side, then whether the discussion between the parties will be taken to the evidence or not, if mediation is not successful. Then it starts with the opening statement of complainant. He describes the issue, to which other party replies to that. If required, we have a private discussion, what we call as a caucus, where either of the parties talk separately to the mediator. Mediator understands them. Mediator tries to give them a reality check, tries to give them options, suggest options. Of course, ultimate decision is taken by the parties. And same thing he may do in case of other party. After the discussion, parties meet again, what we call as again for a joint discussion, and if possible, parties may arrive at a amicable resolution. Believe me, I am telling you, many matters, mediation matters, have been resolved in just couple of hours, which were pending before court for almost years, I am telling you. Because of fundamental reasons I mentioned for dispute, that is ego, miscommunication, and communication gap. So once there is a settlement between the parties, there is a mediation settlement agreement, which is recorded and signed by all the 3 parties, including mediator, which is enforceable in the court of law. Now, what are the qualities of mediator? Mediator is basically, he should be a good listener, he should step into the shoes of other party, and he should be active listener. That helps mediator to resolve the matter. So I always say that mediation would certainly help parties to address the disputes amicably in a quicker manner. It will save the time, it saves the money, and most important, it preserves the relationship. Be it a business relationship, be it a private, personal relationship. I would also like to mention before I go ahead, Mediation Act has been passed by government recently, came into force in a phased manner from 15 September 23. That has given recognition to institutional mediation and also enforcement of mediation settlement agreement. So going forward, I urge, I would say to all upcoming lawyers, whenever they have a contract, they should think of adding a mediation clause in a contract along with other dispute resolution clauses. So parties should at least explore the mediation before they actually go ahead with other dispute resolution mechanism. So that's all from my side. Thank you.
Thank you, sir. We would be moving forward to the next guest speaker for this session, Advocate MITWPU. Advocate on record, Supreme Court of India. Sir has completed his law from ILS Law College, Pune. He was enrolled as an advocate with the Karnataka State Bar Council, Bangalore, consequently qualifying as an advocate on record, Supreme Court of India. He is currently practicing in the Supreme Court of India as an advocate on record and also in various other forums like the Delhi High Court, NCLAT, NGT. Sir appeared in several matters before the Honorable Court of Supreme India and has argued and assisted in more than 40 reputable judgments. He is the panel counsel for the state of Rajasthan in the Supreme Court. Further, has appeared as the Deputy Speaker of the Maharashtra Legislative Assembly and for several cricket association and cricketers in BCCI matters. I request Sir to kindly address the gathering.
before I start, I want to clarify I'm not the Deputy Speaker. I appeared for the Deputy Speaker. So, huge distinction in that sense. Justice Roshan Dalvi, other dignitaries on the dais, my friends in the audience. I'd rather have this as a discussion than as one-way traffic. So if anybody feels they want to say something, please say something. Especially because our topic is mediation. In mediation, I believe you must say something. I find this topic very interesting. Conflict resolution. Sir mentioned, we come from an adversarial system where one lawyer is pitted against another lawyer, and sometimes it is lung power, sometimes it is snide remarks, sometimes it is something else. May not have anything to do with the dispute. And we are conditioned as a system to sort of fight with each other. That's what most people outside, because a lot of people who don't know how the process of the law, process of court, oh, are you fighting his case, is what you will hear very often. The word fight, the word, it is like that. Even we as lawyers are somewhere, to blame for this. I am to blame for this. But today, in the last maybe 25, 30 years, outside this institutionalized court mechanism, we have ADR. We've tried it with arbitration and conciliation, and according to me, to a large extent we are successful. Of course, arbitration, the criticism is always, you wanted to keep the courts out, but really the courts are all over the place when it comes to arbitration. But today we will discuss mediation, because that's really the topic. I mean, you have already been told it's a voluntary process. Nobody can force it on you. In reality, sometimes judges do force it on you. Sometimes lawyers dissuade you from mediation. But when judges sometimes do force it on you, it's not with an ill intent to get the case out of my court. No. Intent with which sometimes judges say, oh, go for mediation. It's to fester some sort of settlement without feeling adversarial. For example, in family disputes or matrimonial disputes, it is almost compulsory that when somebody goes to court, they are referred to mediation. Why is that? Would anybody like to venture an answer? According to me, that is because I don't think judges enjoy deciding who a 3-year-old child should stay with, who should visit at what hour, who should meet where, etc. I don't think judges enjoy it. They have to do it because it's a part of their duty. That's a separate issue. Right? That's really why you want to bring about the parties to sit across from each other and decide it for themselves. Right? There is no need to, as I said, fight. Of course, the problem really is no mechanism to enforce settlements, because settlements are voluntary. A mediation is confidential. Now, these are not problems when you look at it from one angle, but they become problems when you look at it from another angle. And why do I say that they are problems? I have had a mediation where one of the parties would say A today, and if the other party agreed for A, because lawyers frankly have, according to me, a very little role in mediation. It's really the mediator and mostly the parties. If lawyers have a role in mediation, it is really to counsel their clients as to how to go about a settlement process and talks. So I have actually come across a mediation. Why I said it's a problem is, on day one, a party said X. While there was initial resistance from the other party, X was agreed to on day two. Party A's, the first party said, then X plus. Then on the next day, the party said, agreed to X plus. The other party came back with X plus plus. So that's sometimes a problem. But I think the biggest problem which mediation faces today is with lawyers thinking that if we settle our disputes, we are out of work. A lot of times, and it's sad I have to say this, but a lot of times, lawyers dissuade clients from settling disputes. Why is that? Because obviously, economic reasons is one. Obviously, there is a, I'd rather get it in court. Obviously, if you're getting, 5, I'll say, oh, but I'll get you 10 in court. Right? And these are the practicalities of what I have seen and I have faced. However, I think that times are changing. Invariably, matrimonial disputes that arise even as transfer petitions in the Supreme Court, which is not an adjudication of the real dispute, the court almost always says, go for mediation. And my personal, I don't say I have a great success rate in mediation, but my personal success rate is moderately, above average. Because I believe there is no point in a matrimonial dispute to go on in court for 15 years, 10 years, and it's not because courts don't want to work or something. Courts are extremely burdened. It's very well to say, and sometimes we have these discussions, oh, but there are too many holidays. No, there are no holidays. Judges sit in courts for 3 hours, 4 hours, 5 hours, 6 hours. They are doing dictations, they are correcting drafts, they have administrative work. There's a lot. That's another topic for another symposium and another day. But for parties, whether languishing in court, and I use the word languishing because languishing in court, whether it's a matrimonial dispute, whether it's a property dispute, even commercial disputes, commercially, to be disputants in court or resolve disputes and concentrate on business. Questions that must be asked by parties of themselves. What I personally think needs to, I have 46 seconds left, but I think I'm going to overshoot by a couple of minutes. What I personally think needs to be done, according to me, this is the need of the hour for mediation. One, the lawyer community needs necessarily to be assured of their economic security not being taken away. The lawyer needs to be a part of the process in that sense. And the second thing is, mediators need to be economically incentivized. You need expert professional mediators. It's not that somebody is free, so we will get him to mediate, because the unfortunate reality is, and it doesn't reflect on how the mediators function, but the unfortunate reality, at least let me tell you the standard in the Supreme Court Mediation Center, if a dispute is resolved, the mediator is paid 10,000 rupees. If the dispute is not resolved, he or she is paid 5,000 rupees. In 1960, this was a princely sum. Today, it is pittance. And what is the mediator supposed to do? What all is the mediator supposed to do? Part of the process has been explained by Sir. And speakers after me will further explain it, because I've already overshot my time. But a mediator actually has to spend time and energy to sit with parties, understand what really stems, what is the stem of this dispute, try to find a resolution, right, to this dispute. It's not something like 2-minute Maggi noodles, right? It takes considerable time. And if somebody is not professionally incentivized, it's not that they will not do the hard work that is required. It is just not fair. Right? Since we are on the topic of peace, and since we are talking of conflict resolution, I'm just going to talk about something that's not mediation, but perhaps a sister concern of mediation. Most of you were probably aware that South Africa went through one of the worst periods of apartheid, after which Nelson Mandela became the president. During the apartheid period, there was serious violence. Nelson Mandela authorized something called the Truth and Reconciliation Commissions. And that is something that, I'm telling you this because of what we were discussing on peace. Because I find peace to be something that's unique in any symposium that I have attended on any such topic. You must all check out those YouTube or videos on YouTube. The Truth and Reconciliation Commission were aimed at bringing peace perhaps to the soul, sometimes giving amnesty to people who've committed dastardly crimes. The good or the bad of it is something that we can debate on. But for South Africa, it worked. It's more on the reformative side than on the retributive side. That I would like to conclude. I want to thank all of you for giving me a patient hearing. Well, it's not a hearing, but as a lawyer, I think I just end up saying hearing. And I'd also like to request all of you to reflect on what I have said. Thank you very much.
Thank you so much, sir. I would now take this opportunity to invite Advocate S.V. Abhang, founder, Lex Credence, Pune. Advocate S.V. Abhang has over the years developed, expanded, and shaped Lex Credence to be a multidisciplinary law firm with expertise and experience in various verticals of law. He is an advocate enrolled with Bar Council of Maharashtra and Goa. He has completed his master's in administrative law and business laws from Department of Law, University of Pune, and bachelor's in law and social legal sciences from ILS Law College, Pune. His persona lies in strategic litigation, consultancy, solution-oriented approach, and interpretation of law. He has a vast experience in conducting litigation matters before the Supreme Court of India, high courts, district court, family courts, tribunals like National Green Tribunal, Debt Recovery Tribunal, National Company Law Tribunal, consumer forums, revenue authorities, and quasi judicial authorities. I request, sir, to kindly address the gathering.
A very good afternoon to everyone. Thank you so much, MIT, for inviting me. Uh, Dignitaries on the dais, Honorable Justice Roshan Barvi, and other dignitaries of the dais, and my dear friends. So today's topic is very relevant. Like sir also said that instead of alternative dispute resolution, it should be appropriate dispute resolution. And that's what today's times demand. Rather, all of us are resolving disputes on day-to-day basis. And we see that we are employing all such mechanisms. So considering it to be a very cozy winter afternoon, just a break from whatever is happening on stage. So हम daily देखते हैं कि हम किसी दोस्त के पास जाते हैं, अरे वो बात नहीं कर रही, अच्छा तो तू ये कर, तू वो कर, and then उसको जाके अरे वो इतना कर रहा है, बात तो करो. Okay, so this is what? This is nothing but mediation. And this happens on day-to-day basis, not just in our daily life, but also in courts. So whenever we have a matter and we appear for a particular client, these days we tend to interact with the other side's advocate as well. So earlier situation used to be like, if I am entering with the opposite side's advocate, then my client would not like something like that. And then the advocates used to fight a lot, not interact at all, and then meet again in the canteen for a cup of tea. But today the times have changed. We rather go back to our clients and tell our clients, these are the merits of your matter, these are the demerits, these are the problems, and you may end up spending a lot of time and money just pursuing the litigation from one court to a higher court and to the highest court of the land. So what would you achieve at the end? Let us analyze that, and what would be the time frame in achieving that. That if you achieve today and you are able to capitalize on it today, that would help you to grow 10 times more the value of that particular aspect in commercial terms. So this aspect of commercial terms has now come everywhere. Like Amit also explained about matrimonial matters. So today we tell our clients that, okay, you're fighting for alimony and today you're getting lump sum X amount, whereas that lump sum X amount you may never get from a court, you may get a monthly meager amount from a court. So it's better to take lump sum X amount today or to take some property which eventually would grow in terms of value. So if you would get the same amount over a period of 20 years, that's what you're getting today, and you would invest somewhere, you wouldn't get more. So these are the aspects which are seen today, and the benefit is considered of each party to a particular litigation. So today, if we see as far as the adversarial system is concerned, as far as the conventional litigation system is concerned, what does the court do? The court decides the real question in controversy. That's what CPC says. Order 14, Order 6, Rule 17, if we see, what is there? The real question in controversy. So therefore, the court has to decide that one is right and one is wrong. So it is a question about being right and wrong. Whereas when it comes to this ADR mechanisms, I will leave apart arbitration because in that also an award is passed. But the other mechanisms, it is not about being right or wrong. It is about balancing interests. And this balance of interest gives everyone something or the other. Maybe that something which a person gets would be what a person would ultimately want, or with that a person may be satisfied. So if you'll see a recent example as far as the international aspects are concerned, India was quite applauded at the international level. Modi ji's role as far as the G20 aspect between Russia and the West has been quite recognized at the international arena. So it was a different G20 that occurred in 2022 in Bali, where Russia was largely criticized with a very harsher words were used as far as Russia is concerned for the Ukraine war. And if we see the G20 23, which is India's, so there a compromise was brought between the West and Russia, obviously considering a lot of aspects. Maybe the geopolitical aspects are concerned, maybe a lot of aspects. But why I gave you example of this today is that we have been hearing that a mediator is an impartial person. A mediator explains, but as far as these international disputes are concerned, a mediator may be a person who is not impartial. A mediator may also have certain agenda to fulfill. A mediator may also have certain benefits. Like this example only if we take, India has certain benefits to accrue when it plays a good friend of Russia as well as the West, right? As well as the West also has certain agendas as far as this compromise is concerned. So therefore, Russia was happy, India is happy, all the participant states, and West is also happy. Maybe Ukraine is not happy as far as this is concerned. But coming to the same example, what was sought to be achieved is also a common goal. Maybe the food security aspect, the energy security aspects, which are being largely affected as far as the public or the common man is concerned. So today we see, as far as these ADR mechanisms are concerned, they are not just relevant for individual disputes, they are not just relevant for commercial disputes, but they are also very important as far as the international disputes between two countries are also concerned. So we have also had an example as far as the sharing of water of Indus River with Pakistan, wherein the 1947 war occurred and later on the World Bank negotiated and got a common consensus between the two nations. So we have seen these examples by and large in environmental matters, by and large in river disputes, water disputes, aspects within India, outside India are concerned. Or maybe the territorial borders are concerned. So there was this dispute in 1988 which was mitigated between Israel and Egypt. So therefore we see mediation plays a very important role. However, today mediation is reaching the grassroots levels. And the importance of mediation is not just as far as the completion of a matter is concerned or lessening the burden of a particular institution is concerned like courts, but it is more beneficial for the parties. So friends, it was the COVID, and during the COVID the courts were shut down, and I had nearly around 7 to 8 opposite parties, that is 7 to 8 matters which were compromised and which were settled, and later on the matters were withdrawn or some of the matters didn't even go to the court. So there was merely exchange of notices between the parties, and after that the parties, they came together, sat with the advocates, and they discussed what are the pros and cons, and at the same time what would be the commercial impact. So this mediation obviously plays a very important role. It is not just the mediation, there are different forms of it now, hybrid forms of it. Like conciliation is there, which is governed by the Arbitration and Conciliation Act, which is the formal method of this particular aspect. Then after that mediation, now sir has just informed us that it was this year itself, September, that the Mediation Act has been passed, and now there is a formal mechanism for mediation which is governed by statute. So therefore, these particular methods are now being recognized. There are a lot of initiatives been taken. There is National Legal Services Authority, which is working a lot as far as this aspect is concerned. And at each state level, there are the State Legal Services Authority, which are organizing campaigns, awareness initiatives are taken, wherein people are made aware of their rights. So firstly, a dispute occurs, like sir has said, due to ego, miscommunications, and a lot of aspect, or maybe a revengeful attitude as well. But the ultimate outcome of that dispute is what? Is to get a right back, or is to have a beneficial right. Okay. So when we talk about this concept of rights vis-a-vis a person's benefit, then in that case, if we are achieving that through some method which is very fast, which is very economical, and which is less time consuming, then obviously that would be more preferred. However, in India there are some challenges to these methods. For example, when we talk about mediation, one of the challenge which is pointed out by Amit itself. So I'm calling him Amit because we are from the same college and we are friends. So it was a pleasant surprise to see him here. So he pointed out that the remuneration which is given to the mediators is less. There are infrastructural challenges where proper infrastructure is not there for conducting arbitrations. And today we are preferring hotels, luxury hotels, which add up to the economic burden of the particular process or the particular matter. Apart from infrastructure, there are also technological aspects which have to be looked after. So just before parting, I'll give you a short example. You will see pre-trial mediation or pre-trial settlement of disputes mechanism is very much in vogue now. The RTO has implemented and we just get the summons via message. So we get a message on our mobile, we have to just click it and that's a summons to appear in the court. We go to the court, we negotiate and we come to a final amount, we pay that off and the fine is done or the offense is compounded. So technology on day-to-day basis is also playing a very good role because sending this notices or sending this summons also would have been a big problem if that had to be done manually. And slowly we are moving towards a virtual world wherein now these processes like arbitration and everything are being held through video conferencing and we are actually not meeting personally. So there's a lot to tell about this particular aspect, but considering the time constraints, I'll stop over here. Thank you so much for the patient hearing and thank you so much for inviting me. I'm highly obliged. Thank you, everyone.
Thank you, sir. Now it is my pleasure to introduce Dr. Tariq Khan, our next guest speaker, the Registrar of International Arbitration and Mediation Center, Hyderabad, and an adjunct professor at Nalsar University of Law, Hyderabad. Sir is a seasoned dispute resolution practitioner, having a strong background in alternate dispute resolution and a keen understanding of international arbitration practices. He was appointed as a partner of a prominent law firm, Advani & Co. Over the course of his career, Sir has been involved in more than 50 complex and high-stake arbitration cases, both in domestic and international ways. He is also an arbitrator, SIMC specialist, a mediator, and a member of the Chartered Institution of Arbitration UK. A trained mediator and a checkered career establishment, having trained from the prestigious Singapore International Mediation Institute. Sir is also an adjunct professor at Nalsar University of Law and has authored several books in his area of expertise. I request Sir to kindly address the gathering.
Dignitaries on the dais, off the dais, much has already been said. I was thinking, what is it that I can add? When the students came to the university, many of you must have left an emptier home, an emptier room, and your parents have sacrificed for your future. And they knew that this was an important decision, not for them, but for you all, because they understand that education in a prestigious university such as this is key for your career growth. And when you came to this university, MIT World Peace University, you understood that you have a new family and you made friends. And there were challenges that you faced, and then together you overcame. And there'll be times that you'll realize that you have a new family, and a lot of your management and teachers keep sacrificing their own time for your future, for your problems. So may I request you all to first give a huge round of applause for the sacrifice of your parents and your faculty. Now, the reason why I mentioned this may not be related to the topic, but I wanted to start with gratitude. And the vision and mission of the university is peace. And unless you learn the art of gratitude and you inculcate it in your daily routine, not for something, but for everything, the first thing in the morning when you get up, it should be gratitude. Because unless you do this, you will never get inner peace. And only if you get the inner peace, half of your problems will be solved. Now, coming to the topic, because this is of the discussion, and I promise I'll not exceed my time. I've been doing this for a while. Now, can you tell me if there is any court in the world which can heal the emotions of a human being? or which can address the emotions of a human being? Anybody, just raise your hand if you think there is. Anybody on the dais also can tell me if there is. We have very learned people who have been practicing for a while, and Honorable Judge. There is none, unfortunately. And when we go to the court, we have heard the word dispute. Have you ever heard anybody talking about conflict? Has anybody ever heard a conflict? I mean, I practiced for a while, not as much as the others, but they don't use the word conflict. But can anybody, we are all lawyers, we have been practicing the law for a while, and as law students, you are the one who should be telling me what is the difference between conflict and a dispute. Is there anybody who can tell me in this entire gathering what is the difference between a dispute and a conflict? It is unfortunate that as lawyers who are going to resolve conflict all our life, we are not taught what conflict is. The root of a dispute. And dispute is merely the visible part of a conflict which goes to the court in those black and white files, and which a judge has to ultimately decide by applying the law. Fortunately, the judge, who's overburdened by a lot of cases, cannot really go behind the dispute and ask parties why you are here. The judge is looking at a partnership dispute and will apply the law and pass a judgment. But do you think that the parties which are winning in a case in a court of law, they are actually the winners? Do you think any party wins in a court? Nobody wins in a court of law, unfortunately. Even if you win the case, it is over for life. You will never be able to work together with the other party, and the relationships are broken. And unfortunately, that's how we are trained, even in moot courts, A versus B, to compete with the parties. Is there no approach that we can really learn that both the parties can win? Why one party has to lose for the other to win? I ask myself this question. The other thing is, I'll tell you what Oprah Winfrey once said. I think there was a last show that she was hosting. She almost hosted everybody, from all the presidents, celebrities. And in the last episode, she said, one thing which was common, which each and every one of these people asked me right after finishing the interview. Do you know what it was? They said, how was I? Was I good? Everybody needs validation. Pain, fear, and desire. Is there any human being on planet Earth who does not have this pain, fear, and desire? There cannot be a human being. None exist. Only the degree differs. So, human emotions need to be understood. And there is more approach to a conflict than competition. There is avoidance, there is ignorance, there is collaboration. Now, I'll give you one example which I give everywhere. I'm sure many of you must have heard it. Suppose if you go back home today and you see your siblings, two siblings fighting over one orange. There is only one orange. What do? What is the solution? I was doing a training for some international judges. I asked them this question, and the answer, of course, was, and majority people have said, we'll divide it into two parts. I'm sure most of you would tell me this. Now, only if you would have asked your siblings, why do they need it? And one of them would have said, I want to eat the fruit. You go to the other sibling, why do you need it? And the other sibling says, I want to make a face pack. I have a beauty contest tomorrow. I need the outer peel. Now both the parties get 100% of what they wanted. This is called collaboration, which only mediation can teach you, my dear friends. I was attending a conference in 2017. The living legend of law, Mr. Falias Nariman, was speaking. I was sitting somewhere at the back in Delhi High Court. And he said, the future of arbitration is bright, and only because the future of litigation is not. I was very happy because I was doing arbitration and I was like, my future is safe. And I started actively pursuing it. Last year, I authored a book called Everything You Need to Know About Arbitration in India, and I started with this quote, and I was pretty excited. Asked him for a foreword. He wrote a 16-page foreword, and I was very excited to read it. When I started reading the 16-page foreword, nothing about arbitration, only about mediation. I was surprised. I'll tell you 2 lines what he said. He said, I support mediation not because I'm skilled in it, but it is because my experience of 7 odd decades as a lawyer and few decades as an arbitrator has convinced me that mediation shall be preferred not only over adversarial litigation, but also over adversarial arbitration. So there are winds of change. It's a new profession coming up. There'll be full-time mediators in times to come. I think it's a great opportunity for you all to be makers of tomorrow, not just become mediators. And I have personally witnessed mediation making a lot of difference, preserving relationship, and the fabric of peace. I think the most essential element that is required is mediation. That's what we can do as lawyers. And one last thing I'd like to tell, because I promised I'll finish within time, or maybe a little early. You know, we look at every problem like a nail, and we have a toolbox, we only look at hammer, as if that is the only toolbox. And we keep trying to hit hard. What we do not understand is that the toolkit has many, many more other options. We do not have to compete. You know, there are ways to collaborate, and that's what we should look at, win-win for both. And lastly, I'll just say that you all have a very bright future ahead of you. Look at mediation, and if possible, embrace the art of mediation, and that you can only do once you get trained as a mediator. And as students, you can do a training. Thank you very much.
Thank you so much, sir. Our next guest speaker for today's session is Justice Roshan Dalvi, former Honorable Judge, High Court of Bombay. She completed her BCom with Business Management and LLM in Commercial and Company Laws. She has been in the legal field for 45 years, 27 of them being judge. She was appointed judge, Bombay City Civil Court in September 1989, served as principal judge, Family Court, Mumbai, from July to December 2004, and was elevated to the Bombay High Court in June 2005. She was granted a fellowship in peace and conflict resolution for advanced mediation. She is a fellow and vice president Asia of Commonwealth Judicial Education Institute, Halifax, Canada. Her judgments include interpretation of commercial, property, and family law and socio-legal subjects, including proprietary rights of Hindu women, rights of widows under testamentary laws, the constitutional validity of intestate succession of Hindu women, child rights, rights of women suffering domestic violence, human trafficking, human rights of victims, and many more. Ma'am, it's a pleasure to have you here today, and I request you to kindly address the gathering.
Good afternoon, friends. As the last speaker said, much has been said. I would say a little more needs to be said, and let's go ahead. I would like to begin with a little joke. And that is that there was once an old landlady. She lived on the ground floor of the bungalow. She let out her first floor to a young man. This young man had many friends, and he would call them over in the evening, and they would party late into the night with music and dancing and whatever. One of his friends asked this boy, I don't know what your landlady will be suffering when we go on dancing and singing and shouting. He says, oh, don't worry. We have mediated. In the morning, I take out her garbage box. In the evening, she pulls out her hearing aids. This is what actual people do in actual life, not only with an orange, but with the whole house. Now, friends, how far has this gone and where did this start? We were told that our panchayats, etc., we had this as our tradition. It was forgotten. We went into the adjudicatory mode. Then came the Americans and said, oh, we are doing this and it is a great success. 94% of our litigation ends in mediation and is very successful. So we started taking it up. And then we had to see the ground realities of India. So, whilst we were mediating, and we are all first generation learners of my friends and me. So when we started doing it, we realized that there is a lot of power balancing which requires to be done. There is a large corporation and there is a small contractor. There is a bullying husband and there is a violated wife. There are neighbors. There were disputes of flower pots in my court once. That is what I adjudicated. There are n number of things. They are like snowflakes. So how do we do it? So we have to give them a push. That is, friends, creating options. Sometimes people say mediator cannot do anything. Mediator have to get the parties together and the parties must decide. Yes, but the parties must be capable of that decision. When the party is not, the mediator has to nudge. The mediator has to create options. And that, friends, I would say, is the doctrine of POS. First find the problem, P. Then create options, O. And you get the solution, S. Okay? It's not as simple as that, but ultimately the bottom line is only POS. Okay? Now, friends, you are youngsters, you are the second generation learners. And you must go far ahead of what we have gone. You must not make the mistakes that my generation has made. You must not have lawyers who will say that all my briefs will be taken away, as somebody just said, and wrongly, and therefore I don't want to settle. I don't want my parties, my clients to settle. You have to tell your clients to settle, but you must tell them how to settle. That is the skill that you must learn in your legal education. And friends, when you are learning that, what you will do is, there is a collaboration, as some speakers have said. What is that? It is lawyer-lawyer, client-client. Lawyer-client, lawyer-client. It begins, now we know, with notices and all. When, friends, you are going to give notices, you must give the notice. They say, no, we will be taking you to court and you will be responsible for the costs and consequences thereof. It always comes, it is auto-texting. You must say that I will take you for mediation and let us see if we can have a win-win situation so that we both can be happy. Not extremely happy, but happy enough to go away. That is what mediation does. Doesn't make anyone extremely happy, mind you. So don't go with all those exalted thoughts. Just happy to walk away. Just happy to take your life, take the roots of your life and go ahead with your life. We tell that to husbands and wives, we tell that to contractors, we tell that to all of these kind of people, mainly those. So there are two things. One is when the bottom line is money. Okay? So you have to negotiate and find out what is that main thing. There are some principles. Robert Mayers has written a book, How to Win Any Argument. And in that he has given those 6 principles, which I take it you'll take it from that book. It's a small book, very interesting. Sriram Panchu has written a book, How to Get More for Less. So, how to get so many things. And he has given a very good illustration of a commercial dispute before him, where he said that, you see, one party had given the loan and had to get some raw materials, and the other party had to make finished goods. But the goods were not made, and therefore, when the goods don't come, the entire business line suffers. He cannot export them, he cannot sell them in the market. So therefore he goes into arbitration. And And they said, how do we solve this? Because this man has not given it. He says he's a defaulter. He's a fraudster. No, he was neither a defaulter nor a fraudster. In arbitration, we do not have to find out why he did what he did. We have to find out what both parties did, whether it was legal or illegal, and give an award. Or, of course, a judgment in adjudication. But since Sriram Panchu went ahead and wanted to mediate, he wanted to find out why they did it. And this man says that I am not getting the raw materials to make this finished product. If I get it, I would really give the finished products in time. How would he get it? He required finance, which he did not have. So now, who is going to give them finance? The bank said that no, he doesn't have much of security, so we are not going to give that loan. One small officer of that claimant corporation said, why not we give him the loan and let him get this raw material so that he can make our product so that we can then export. And everybody laughed at him, says Sriram Panchu, until they realized that he was right. And they did that. They gave the defaulter more money to get the raw materials, to make the finished goods, and the defaulter readily agreed that as soon as I make it, 75% of what I make, I will pass on to you in discharge of my loan liability. Everything worked. They remained friends. Now, friends, as we go ahead, what I find is some people vow for mediation. Some people say, no, it doesn't work, only adjudication. And some say, yes, arbitration, because ultimately it's adjudication. As an arbitrator and a mediator, what I find is our made is the best. Now people say that first you say, you mediate, and we will give you that mandate that if we cannot settle, you give the award. But in that there is a slight glitch. That is what I have found from my experience as an arbitrator when I have been asked to mediate, and I have stopped that. Why? Because in mediation, people tell us many things that is not on record. But when we have to give an award ultimately in arbitration, because we are mediator and arbitrator, and that is what happens abroad, we cannot take that into consideration. We may make a mistake. We have to go by the record. And the main thing has to be forgotten. So what we do, friends, what rather I do, friends, as via media is listen to both of them. Quite often in the interim application, everything becomes clear. As a judge, I knew that when I take an interim application, both parties are very ready, both lawyers know everything threadbare, and I get ready also. I know what the matter is about. I know whether to send it for mediation or not to send it for mediation. Because there are most matters that may go, some matters that should not go. Similarly, in arbitration, we come to know this. If not, we read the papers. Papers reading is a must. So the claim, the SOD, find out whatever, that is the dispute that is between us. The real hint, friends, I would tell you, whether you are a lawyer or a judge or an arbitrator or a mediator, is to find out what are the admissions in any dispute. There are. They say, I deny for 27 pages. But on one of those pages, you will find a very important admission. And you will know that only if you read all the papers threadbare. Now, when you record those admissions, and there's a very salutary provision in our CPC, Order 10, Rule 1, which makes you do that, then you narrow down the issues. Then you have to decide and adjudicate either as a judge or as an arbitrator on those disputes. We are doing that. It takes a little time. Never mind. Don't start only mediation right from the beginning. Now, what I do is, I decide all of these because I narrow down the dispute. It becomes quickly. I'll finish my arbitrations in 6 months, 7 months, 8 months also. At the time of the award, I keep it on another day at 10 o'clock in the morning, and I request both the lawyers to come, because otherwise they'll say an award will be given, we will read it online, which I give online. I say, no, please come, and your parties also. They come. And then I offer them that I will be a mediator if you want, at no extra cost because you paid my arbitration fee. And I mediate for the entire day. The real test of American success in mediation is that they don't do it for just 2 hours, again adjourn, another 3 hours, again adjourn. They don't do that. They work for 10, 12 hours at a stretch on a given day. Now you get the parties together. The parties tell me, can I get my brother in? Can I get my mother in? I say, you get everybody in. I start that. Even if it does not settle, and quite often it doesn't, the seeds of settlement are sown. Now when they take my award, I tell them that if we settle, I'll tear out my award. And if we don't settle, I will give you the award today itself. I am ready. The award is there, sealed, signed, and kept. Now, if they take the award, one party would go for enforcement, another party would go for challenge. They are going to meet again. When they have discussed things with me, and I say that you keep your relations, your business relations, your family relations intact so that you have another contract. Just as we have another matter, like you lawyers will have another matter of that same client. Similarly, what I would say is that keep that in mind. They would keep it in mind, and I've been told at other forums that, ma'am, that award which you gave, no, that so-and-so challenge, no, now we have settled. It is because they have thought. They've gone home and it has sunk in. Because we have taken up all the issues. Legal issues are in my award. The other issues, the interest part, not the position, not the legal position, but the interest. And we go ahead. And this is even what happens in international mediations, which I will not go into now. So thank you, friends, and I hope you go that far.
Thank you, ma'am. We will now be moving on to a significant part of the session, the resolution. In the pursuit of a peaceful dispute resolution, we, the participants of the conflict resolution with special reference to ADR and mediation session, reaffirm our dedication to advancing alternate dispute resolution methods, recognizing the efficacy of dispute resolution and mediation. We pledge to promote these approaches as valuable tools for resolving conflicts. Our commitment includes speedy disposal of cases, raising awareness, building capacity, and advocating for the integration of ADR principles into legal system globally. Through these efforts, we aspire to contribute to a world where disputes are resolved amicably, fostering enduring harmony and understanding. Everyone who agrees to this, kindly raise your hands. Since most of the people agree to this, the resolution hereby has been passed.
As we near the session's conclusion, I would request Dr. Shruti Nigudkar, Program Director, School of Design, MITWPU, to render the concluding remarks and the vote of thanks. Over to you, ma'am.
Thank you so much. I'm not going to take much time, but I'm sure that everybody must be wondering why Director of School of Design doing the conclusion and vote of thanks. So I feel that, this session is being live. And I feel mediation, the way lawyers and people in the judiciary, we need to also educate the common people. And I think I am a representative of those people. It is my privilege to deliver these closing remarks and to extend my heartfelt thanks for, allowing me to express my gratitude here on the 3rd International Symposium on Law and Peace, which is hosted by Vishwanath Karar's MIT World Peace University School of Law. Our discussion themed conflict resolution with special reference to ADR and mediation. It's a very captivating subject. It's an interplay between law and peace. So can law play any significant role in nurturing and maintaining peace? That's the question. And I feel that everybody was speaking about how it can be, achieved. Our first speaker, Advocate Manish Asarkar, he spoke about our age-old tradition, and he actually gave us a thought, as to how we can, as being the Bharat Vasis, how we can go back take something that is good and also look forward and, integrate the both. Sir, it is my pleasure and honor to offer you the vote of thanks. Thank you so much for coming here and talking to all of us. Yeah, I will also like to thank Advocate Amit Patil. Uh, he very pointedly spoke about pragmatism and how practical approaches make all the difference in the decision makings when it comes to the legal affairs. I will also like to thank Advocate S.V. Abhang. Uh, he took that same point ahead and he was talking about how we can balance the interests for mutual benefits, how we can actually, if I may say so, use the common sense which goes for a toss whenever there is a conflict. How time is valuable for us, how money is valuable for us, and how we can focus on that. I will like to further thank Dr. Tariq Khan. Sir spoke on the very pointed aspect of emotions. Everything is okay, but whenever there is emotion, we say na everything is fair in love and war. So that is the point that we also need to consider. Thank you, sir. And finally, I'd like to thank Justice Roshan Dalvi. Ma'am, she gave us some tool, the pause of the possibility, the beginning of the possibility. And she spoke about creating options. I feel that's the most important thing where everything can come and align into peace. And I'm very thankful to everybody that, you took this opportunity and this option of attending this seminar. I will like to express my gratefulness to our revered Professor Vishwadharmi, Dr. Vishwanath Karad sir. His dedication to world peace is profoundly evident in his visionary act of naming university itself called World Peace University, and I'm sure everybody will agree with that. It's a very important decision because this brings academics in hand with peace. I'm grateful to our Executive President, Shri Rahul V. Karad sir. He is the conceptualizer of initiatives like NLC Bharat, like, breaking the colonial minds, which we are talking often nowadays, and also the founder for School of Government. He's a huge inspiration for all of us here. Thank you, sir. I will also like to mention my gratefulness to our Vice Chancellor, Professor Dr. R.M. Chitnis, sir. Our Dean, School of Law, Professor Dr. Sunil George, and Associate Dean Purnima Inamdar ma'am, for bringing their team together to make this amazing symposium possible every year for the students. I will also like to thank the anchor students who anchored really well. I think we should give them a great applause. And also anchor Anuttama Ghosh ma'am. Thank you so much. And I'm looking forward to many more sessions. Thank you.
Thank you so much, ma'am. With this, we come to the end of this session. I thank all the esteemed panelists for being the reason for this session to be a grand success. All are requested to remain seated because there will be an announcement following hereafter. Thank you so much once again.
Okay, dear students, there is an announcement for all of you. So the session is over. You all can go for your lunch now.